Morning, everybody. So this panel is the role of the lawyer in class actions. I'm Ed Coulson from Bryan, Leighton, Paisner. I'm joined by Joanne Gillies from Pinsent Masons, Seth Harrington from Orrick, Herrington and Sutcliffe, and Russell Poole from Berger, Montague. I'm going to just ask each of the panelists just to give a sort of 1-minute overview of their practice, just to sort of as a sort of reference point for some of the discussion we're going to have on the panel. So I'll just kick off. My practice is in the UK, focusing on competition, antitrust and regulatory disputes. So cartel damages actions, abuse of dominance and such like, and invariably those claims involve group litigation of one sort or another. Joanne?
Yes, good morning all. I'm Joanne Gillies, a partner that specialises in financial services litigation with Pinsent Masons. I think I was getting mic'd up when Liam mentioned Scottish gangsters a bit earlier, but in any event, it's very nice to be here this morning. My practice so far has been exclusively for defendants, so I'm just pinning my colours to the mast there. And I presently have conduct of high volume, low value litigation for a number of UK clearing banks and other financial institutions, primarily focusing on product mis-selling and data breach claims. So I've also advised on collective redress schemes, so that's prior to pre-action stage. And I've seen it all through from evidence gathering, disclosure, and I've litigated hundreds of cases to trials, and all the way through to second appeal in a couple of test cases. So I'm part of a team that works right across the UK, but predominantly the focus is on English county court actions.
Russell.
So I'm Russell Paul. I'm a partner at Berger, Montague. We're a full-service class action firm based in Philadelphia, and I think I'm the only plaintiff's lawyer on the panel today, but I'm used to being surrounded by defense lawyers, so I'm quite comfortable here. I just want to list for you the areas of our practice at Berger Montague, because it's kind of it'll segue into what I'm going to talk about later, and it shows how ubiquitous class actions are in the United States and how they really can touch Americans in many aspects of their lives. So we practice in the areas of antitrust and consumer, which has 4 or 5 subspecialties, including credit reporting and background checks, automobile defects, defective drugs and medical devices and other defective products, securities and commodities, employment, environmental, insurance fraud, privacy and data breach, key TAM cases under the False Claims Act, human rights, and predatory lending and borrowers' rights.
Thanks, Ed. Seth Harrington. I'm a partner in the Boston office of Orrick in the United States. I'm a complex litigator handling multiple types of commercial litigation, but primarily focused on defense in privacy and cybersecurity breach claims. Not, surprisingly involves a significant number of class action litigation, as we learned yesterday, and had a very, very lively discussion on data breach class actions, but also regulatory investigations and enforcement. And I think we'll be talking a little bit about sort of the counterbalance between a regulatory action and class actions in the U.S., as well as insurance litigation, and look forward to this panel discussion on these 2 perspectives.
Thanks very much, all. So this panel is, as I said, going to discuss the role of the lawyer. And just by sort of way of intro, really, for many in England, I think it's fair to say there remains a sort of classic view of plaintiff lawyers and class actions. Class actions being viewed by many as something brought by lawyers for lawyers. And in fact, those views are evidently shared by members of the UK government and some members of the judiciary as well. So, from the government's perspective, the recent government report on the consultation into whether to introduce opt-out data breach claims, which concluded not to, albeit pre-Lloyd and Google, noted that in the US, such claims have, quote, given rise to a compensation culture that tended to benefit claimant law firms and litigation funders more than ordinary people. And that sentiment echoed by some of the judiciary here as well. So at first instance, the first instance judge in the Lloyd and Google characterized the claim as officious litigation embarked upon on behalf of individuals who have not authorized it, and in which the main beneficiaries of any award of damages would be the funders and the lawyers. He thought that the representative claimant should not be permitted to consume substantial resources in the pursuit of litigation on behalf of others who have little to gain from it and have not authorized the pursuit of the claim, nor indicated any concern about the matters to be litigated. So I just wanted to raise that. That's still, I think, quite a common view in this jurisdiction. I also agree with something someone mentioned on one of the panels yesterday, that whenever class actions are discussed in this jurisdiction at a policy level, people go out of their way to stress that what we're doing is nothing like US class actions. They will expressly not be like US class actions. Indeed, in the Competition Appeal Tribunal here in the UK, which has introduced the most developed class action regime, we're not actually allowed to call them class actions. There was a deliberate decision to refer to them as collective actions in the relevant rules and guidance which governs them. But with all of that said, it's obviously clear that class actions, collective actions, group litigation of one sort or another, and the associated lawyers, with every year that passes, they enter a bit more into the national psyche here. And that, of course, is in part pushed by plaintiff lawyers, sure, but it's also a feature of the world we live in, with the mass production of goods and services and the ever-increasing prominence of digital technologies and the role of data, which obviously impacts on large numbers of people. And in fact, indeed, Lord Leggett, whilst of course calling a very firm halt to Lloyd's representative action against Google in the Supreme Court, did acknowledge that the reality of the virtual world, noting that the development of digital technologies has added to the potential for mass harm for which legal redress may be sought. So whilst we can debate for sure how niche or how prominent class actions are going to become in this jurisdiction in England, they're certainly going to be around in one shape or another. So on this panel, we're going to discuss a bit more and look a bit more about the role of the lawyer beyond the stereotype, if you like, and think about the role of class action lawyers as outsourced state enforcement. We're going to consider a bit, do defendants ever actually welcome class actions? And look a bit at some very practical issues of claimant and defendant class action lawyers that they face. So with that sort of intro, we'll kick off with the sort of first question. And let's start really with the role of the lawyers at a high level. Do they drive class actions? If they do, does it matter? Who else would be better placed? And can we talk a bit about the role of the lawyer as a private state prosecutor? So Russell, do you want to kick us off?
I do, and I object to some of those derogatory comments about American class action lawyers. Are class actions lawyer-driven in the US? And certainly it depends on what you mean by lawyer-driven. Plaintiffs' lawyers don't invent the frauds, we just prosecute them. And what are class actions? They're a private, market-based means of enforcing the law and a way to hold companies accountable. So I like to say that we don't drive the class actions, but we do get behind the wheel and steer them, as we're supposed to do. So what are the alternatives if private plaintiffs' lawyers don't do it? Well, the corporations can police themselves, not a good idea. The government can enforce all the laws and recover money for the defrauded citizens. It can do that. Or no one does it. Those are the alternatives. If the government does it, that's a bad idea. And here's why. Because government bureaucrats get a salary. They get the same pay no matter what they do. They're not motivated really to get results like the private attorneys are. And a very good example of that is the False Claims Act in the United States. I don't know if you're aware of this. They're called qui tam actions. They were begun in this country. Qui tam's from a long Latin phrase that means standing in the shoes of the king. So a private citizen can stand in the shoes of the US government and sue any company to recover money that's been defrauded from the US government. And federal prosecutors around the country are tasked with intervening in those private actions and then pursuing the case on behalf of the government, but they don't have the resources to do it, and they often don't have the sufficient motivation to do it, and that's where the private attorneys come in, and we prosecute those cases on behalf of the government. The next real issue with governments doing it is what's called cronyism, and that's the idea that the government is biased in favor of people who give money to the political party in power. So the government lawyers don't necessarily always make the decisions in the best interest of the case. They're looking to other considerations besides wrongdoing to know whether they should prosecute an action. And of course, the private sectors have a much purer motive. They have an economic motive to pursue these actions. And here's a very good point. Class action lawyers do a better job than government lawyers do when they go after corporate wrongdoing. If you compare the private securities fraud bar to the Securities Exchange Commission in the United States, in any given year, the securities bar recovers 10 times the amount of money that the SEC does. And of course, the private bar has greater resources to do that. They can go after more wrongdoers. But a study has shown that even when the SEC and the securities bar goes after the exact same wrongdoers, the securities bar still recovers 4 times as much as the SEC does. When the federal government goes after corporate wrongdoing, most of the time it's prohibited from returning the money to the citizens. The money has to go back into the US Treasury, so that's effectively a 0% claims rate. Occasionally, the government is allowed to return money to the victims by statutory means, and the government goes and uses the same settlement administrators that the private sector does, and the government's claim rate is about the same as the plaintiff's bars is, around 10%. Another reason to allow private attorneys to sue in so many different areas is deterrence. Even the existence of the class action deters corporate wrongdoing. Brian Fitzpatrick, a professor at Vanderbilt Law, wrote a book in 2019 called The Conservative Case for Class Actions, and he did 5 very good empirical studies, 1 antitrust and 4 in the securities fraud area, that shows that as the class action threat goes up, corporate wrongdoing goes down. And the vast majority of settlement money is distributed pro rata to the class. So in a settlement where there's a fund set up, all the money goes to the class, and it goes pro rata to the class. So that means that if all the money isn't used up on the first round, then on the second round it goes to the same people that made claims. On the third round, it goes to other people in the class. All the money goes to the class. There are claims-made settlements in the consumer class action context, and the claims rates are a little low. They're about 10%, maybe a little bit higher lately, and that's something that the class action bar constantly works on. The settlement administrators constantly work on. I note that there's this U.S. Supreme Court case called the Boeing case, where judges are allowed to give lawyers a percentage of the face value of the settlement. So even when there's no fund set up, when there's some kind of recovery for the class, I do a lot of auto defect litigation in the consumer context, and a great win for the class is an extended warranty that covers the vehicles for a number of years, so that goes to all class members. They don't have to make a claim. There's no money involved in those classes, but still there's a great value to that, and the lawyers are allowed to be compensated for that value, so they're sufficiently motivated to get that recovery for the class. There are certainly checks and balances in place. There are many of them. U.S. judges have a lot of discretion over whether to certify classes and what to pay the lawyers. There are ethical rules that lawyers have to adhere to, or they cannot or will not be able to continue practicing law. And of course, there's Federal Rule 23 in the U.S. That's the driver of class action. So there's a lot you need to show to have a class action. You need to have numerosity, commonality, adequacy of representation, typicality, and in most classes you need predominance and superiority. Those are very high thresholds to meet. So there are some criticisms of class actions that are fairly typical that I would just like to counter. So there's a perception in the public that the plaintiff's attorneys make decisions in these cases in their own interest, their private interest, monetary interest, and not in the public interest. And that can cause the public to lack confidence in our U.S. system. But as a general rule, plaintiffs' attorneys and the putative class member interests are very much aligned. Certainly, as the more we get for the class, the greater our fees are, the greater the outcome is. And there are constraints on those fees and on the profits that can be gained. There are those ethical rules and judicial oversight. Another common criticism is that plaintiffs' attorneys prosecute meritless cases in the United States. It's really not true. Meritless cases do not survive in our American federal court system. The threshold on a 12b6 motion to dismiss is governed by 2 Supreme Court cases, Twombly and Iqbal, and the allegations must be plausible on their face. Not just possible, but plausible. And certainly federal judges define that a little bit differently here and there. Some require super plausibility, so they dismiss the complaint and make us go back and plead it even in more detail. Every year, the U.S. Chamber of Commerce publishes their top 10 list of frivolous lawsuits. And you know what? When you look at those, they're not really frivolous. One of the cases that they chose was a wage and hour case against Starbucks, where an employee argued that he was entitled to be paid for the time he spent closing the store after he had checked out. He activated the store alarm, he locked the door, and he walked his coworkers to his car. These are tasks that require an additional 10 minutes each day. And in the US, wage and hour cases are opt-in, not opt-in classes. The Supreme Court upheld his specific claim. They said that employers must pay workers for minutes they spend clocking out, locking up, setting the alarm, etc. He was seeking for himself payment for 12 hours and 50 minutes of work over a 17-month period. At $8 an hour, that meant $102.67. The Supreme Court of California said, quote, "That is enough to buy a utility bill, to pay a utility bill, buy a week of groceries, or cover a month of bus fares. What Starbucks calls de minimis is not de minimis at all to many ordinary people who work for hourly wages." The next criticism is that class action lawyers get too much money. Bryan Fitzpatrick, this Vanderbilt law professor, did a study, and he added up every dollar that defendants pay out in class action settlements and compared it to every dollar that judges award class action lawyers. And he found that the lawyers are only getting 15%. That's much less than the normal 1/3 contingency fee set in the American jurisprudential system. So he actually argued that we should be paying class action lawyers more. Now, while it's true that the average fee in a class action is about 25%, not 15%, because the judges, they tend to give much lower percentages in the very high damage billion-dollar settlement cases. But even at 25%, the average rate, it's still much less than the normal 1/3. So the system is working, and judges in America are exercising their discretion wisely. The percentage of class members that get paid is low. That's another common criticism. It's about 10%. You know, it is true, and we do work on that constantly. I have a couple responses to that. First of all, it doesn't mean that the other 90% goes to the lawyers. It doesn't. It doesn't exist. It all goes to the class, the funds that are earmarked for the class. And the alternative here, that the federal agencies will get the money and give it back, doesn't necessarily mean that there'll be a higher claims rate. There won't. And actually, courts now in the US are starting to look at the claims rates before giving final approval to the settlement. So in our system, you get preliminary approval of the settlement, and then notices go out, people can start submitting their claims, and before final approval, and the judge can actually delay final approval to see what the claims rates look like. And interesting to note that during COVID, the claims rates have soared in the US. And that's the end for that.
Thanks very much. Seth.
Thanks, Ed. Just to add some thoughts to what Russell's very interesting, detailed points, and provide a defense perspective a little bit. Yeah, I think I agree that litigation is more driven by the lawyers, but there are, as Russell points out, there are many different sort of voices as part of the class action. There's both the plaintiff side and the defense side. The court serves a significant role in approving lead counsel for a class, setting the schedule that the parties have agreed, and sort of policing and deciding those key moments about certification of a class or an approval of settlements if there is a resolution. But also insurance plays a significant role, at least on the defense side, in how cases are managed and proceeded. So it's a big influence from our side of the V. Because funding is really not as prevalent in the United States as it is over here, as I'm learning more and more about the system in the UK. Although I think there are some inroads, but it's just not as prevalent. Finding myself sort of surprised, not surprised, but interested that we're in agreement on a view about the role of the government in policing these actions. Certainly, particularly in privacy and cybersecurity actions, particularly where there's a data breach, a company can expect to face both a class action brought on behalf of those individuals whose information may have been accessed or misused, as well as an investigation both by federal authorities and by state authorities. And sort of seeing both sides of those things can definitely appreciate some of the criticisms that Russell has highlighted about sort of the inefficiencies and burden of a regulatory investigation, a regulatory regime that drives the cost and exposure for a company. And but there are sort of some advantages to that. The regulatory investigations often are more private, and a company may appreciate that the investigations are not as public as some of the allegations and litigation that comes with class actions. But certainly the role of the class action lawyer is more, as you say, more purely, the motivations are more purely known as opposed to what you may see in a regulator. And we see, I think, there's sort of a hybrid, a quasi role for the class action lawyer, where states and the federal government have established a statutory damages regime that sort of establishes a minimum amount of recovery per violation or per claimant that essentially anoints the class action lawyer as a quasi-state prosecutor to enforce those rights in a way consistent with some of those philosophies that Russell highlighted, but it's at the same time having some sort of authority of the government. And I like to think, that the role of the defense counsel is to serve as that sort of check and balance that Russell highlighted. That by having an adversarial system, by having a strong defense bar, ensures that truly meritless claims are disposed of at an appropriate stage, and that the valid claims are proceed where they are supported by the facts and the law.
Thank you. Yeah, I'll pick up on a couple of themes that come out of that. One, I think, is deterrence and enforcement of the law. I think, quite understandably, there's a big focus here at the moment on what damages to pay out, the compensatory principle, and plaintiff lawyers. However, I think a big part of the policy, certainly in the competition sphere here, in introducing, or both promoting private enforcement of competition law per se, and then promoting also collective actions in that space, is that deterrence point, and it's about ensuring enforcement of the law. Obviously, public authorities have limited budgets, they have prioritization rules, and I think that perhaps in recent times that emphasis on deterrence and why we're having this system has been lost. So I think I would echo that theme that Russell mentioned on deterrence there. Secondly, and interesting on the challenge that Russell responded to, that claimant lawyers are just following their own interests, and then he obviously rebutted that. I think it's interesting, one of the comments I recall from Lord Legate's judgment in Lloyd and Google is when he's talking about the fact that he can see classes having quite divergent interests in them, and that wouldn't be a conflict, that would still satisfy sort of commonality issues. He makes the point there that it's actually in lawyers' and funders' interests to represent all class members' interests to the maximum, so as to hold the class together and maximise the claim. So actually, he is suggesting that the incentive there is actually to represent everyone's interests to the full, because that, of course, maximises the claim. So I thought that was an interesting echo from that judgment. So moving on, and slightly flipping it on its head in a way, in what circumstances do defendants welcome class actions and their lawyers? Do they ever, or do they never? Joanne?
Thanks, Ed. Well, I suspect it would be something of a stretch to say that defendants ever welcome class actions, but I think their prevalence now is now accepted as part of the fabric in which big business operates, particularly given increasing digitalisation. And I think it is accepted that there certainly can be a benefit in dealing with, in some cases, one claimant firm or a small handful of operators on behalf of claimants, as it can allow defendants to streamline their processes, for example, allowing efficiencies in terms of document production and evidence gathering. And I think it's as someone who's advised on collective redress schemes where businesses are having to interact with consumers directly, I think having legal representation is advantageous, because otherwise claimants may struggle to articulate their complaints successfully and indeed accurately. So I think that's the sort of backdrop that big businesses approach this. And I also think that certainly in the UK, the fact that we've seen some maturing of the claimant firm market, I think that has also helped, so that I think claimant firms, and I suppose I'm thinking in particular here of claims management companies now accept that they are subject to scrutiny, to supervision and regulation, just the same as the rest of us now are. And I think that has been a good thing, although in my experience I must say that sometimes the data that they're working with can vary hugely. Seth, did you want to come in terms of what might be the case in the US?
Sure, yeah, and I appreciate your comment about whether the defendant really ever welcomes litigation. But certainly in the U.S., having a single litigation to dispose of or deal with multiple claims, multiple claimants in a single proceeding, particularly where you have in the U.S. the federal system as well as individual state systems, certainly having a single federal class action is much preferable to having multiple state individual proceedings in different jurisdictions where you could have different schedules, different burdens with respect to discovery, and particularly as you highlight the increased costs of dealing with digital data and discovery, but also inconsistent rulings and just creating additional headaches there for defendants, and of course where you have a single federal class action, you can often have a stay of any individual other overlapping proceedings, and so you can avoid that inconsistency as well. It's part of one of the main advantages. And one of the things we've seen and highlighted in several of the panels yesterday talking about as the proliferation of class action waiver and arbitration provisions, one of the strategies in response has been mass arbitrations and filing of multiple individual arbitration filings, which can produce not only that inconsistency, but could also significantly increase the costs to defendants having to deal with the cost of multiple hundreds or thousands of arbitrations, that where a class action would be a much more economically efficient method for dealing with the claims.
Can I jump in? So I have an example where we filed a class action against Toyota for certain hybrid vehicles that had a defect in their fuel tank, and got a call from defense counsel, who I know, who said, thank you for bringing this class action, because we know there's a problem, we want to clean it up, we actually have a fix that we plan to implement, and we'll do everything through the class action, and we'll get a release from the entire class, so we cannot be sued again over this issue. So the system can work really well.
Yeah, I wanted to echo that, but also just follow up on that. I mean, that sort of notion of global peace, if you like, or finality, and obviously it comes with the streamlining, but also the finality piece. And I don't know, Seth, whether you've got any more thoughts about achieving that finality, and whether defense lawyers seek to really use it as an opportunity to achieve finality on an exposure to litigation. And equally, Joanne, I don't know whether there's some echoes there from voluntary redress, where there you've got obviously, generally you've got a sort of public investigation or regulatory investigation, which leads to a degree of finality, though, if there's a voluntary redress scheme. And just any thoughts on class actions as another avenue to achieve that sort of finality, if you like?
Yeah, no, and I think to pick up on what you said earlier about the wanting to have the class represent as wide a variety of individuals as possible, certainly when you are looking to have a settlement with a class, you want that class to be as defined as broadly as possible, so that you do have that finality of a release and resolution of that exposure. And that's one of the advantages to a defendant in a class action opt-out scheme, where basically you can be assured that as long as only a few individuals are opting out of the class, that you have that wide finality, and you can certainly build into any settlement agreement some limitations if there is a significant number of opt-outs. Of course, all of this is weighed against the fact that in the hypothetical absence of a class action scheme at all, would that exposure have existed? But as Joanne points out, this is the world we live in, and so it's better to have a system that we can work with and achieve that finality.
Yeah, and just to pick up on the redress point, Ed, I think it's a really interesting issue, because there's a wave of claims that I'm dealing with at the moment where the claimants have actually been through a redress scheme, but are coming back to the court for a second bite of the cherry. So at least I'd like to think that after this wave, that will be it. So actually litigating some of these issues, and running test cases and trying to create some stability, at least insofar as the legal framework is concerned, I think that can only be a good thing for defendants, but also for claimants as well, so that they know where they stand.
Yeah, and I imagine there's some real challenges there in the sort of double recovery issues, particularly dealing with such a huge volume of people. How do you ever know? Let's move on then and look at some practical key issues, first from the claimant class action lawyer perspective, and then from the defendant class action lawyer perspective, and look at some sort of practical examples of things people have faced. Russell, do you want to address a couple of claimant ones?
So the first key issue for a plaintiff's class action attorney is, should I pursue the case? It's a really important decision with major consequences. And so the first thing to do is get all of the facts before you decide to pursue the case. And you have to analyze, does this case make economic sense? Look at the class size, look at the average damages. Where will I bring the case? Is there a good jurisdiction to bring this case? There's a U.S. Supreme Court case called Bristol-Myers Squibb that's affecting where cases are brought in the U.S. if you want to assert a national class. And so most cases are being brought either where the company is headquartered or where the company is incorporated. So in many instances, in the auto defect world, many of the headquarters are in Detroit, Michigan, and many are incorporated in Delaware. Is there an arbitration clause in a class action waiver? You have to be very careful and search for those. You have to analyze all the legal issues involved to make sure you can meet all the elements of the claims you intend to bring. And you have to know the players. Who's the defendant? Who's the defendant's counsel? Are you in for a very long battle? Or is this a company that likes to settle things quickly? Once assigned, who's the judge? What is the judge's track record? A judge can have an enormous impact on the progress of a case. And also when looking at a case, you have to see how it fits into your portfolio of cases. In the auto defect world, we have a number, we try and diversify. So we have transmission cases, engine cases, battery cases, tire cases. Diversification is key. And also, is there a history of good decisions in that particular area? We have a number of cases, one against Volkswagen and one against Subaru for their autonomous emergency braking systems. These are relatively new systems, and they have bugs in them, and they can be quite defective, but there has not been a ruling in the area yet. So we're going to take a wait-and-see approach. And once you decide to take the case, the next key issue is hire the experts. Hire them, hire the right ones, and do it early. They are expensive, but they bring incredible value to your case. They can examine the facts with an eye towards class certification, which is a major tipping point in the litigation. So the experts will help you frame the issue at the outset. It's incredibly important so that it survives the motion to dismiss, the 12b6 challenge, and ensure that the issue is common among all the class members. You have to develop your litigation with the end in sight. So what is the end game? What relief do you really want for the class? Is it money? Is it something not money-based, like a warranty extension? And remember, your settlement is only good if it gets final approval. If it doesn't, it's not a settlement. You have to define I want to add to that in the American system, before a case is finally approved, before settlement is finally approved by a judge, any member of the class can object to the settlement. They can write to the judge and say, this is why the settlement is no good, or the fees are too high, or the class members are not getting enough, or there's a conflict between members of the class. So that's another way of judicial oversight of the entire class action scheme. You have to define what victory means. So you have to look at the size of the class, the length of the class period, and sometimes victory is not a class action settlement. It's maybe an individual settlement with some class action, some class-wide relief. So that means that it doesn't go through the normal processes of judicial approval, and also that defendant does not get a class-wide release. The next real issue, and the most difficult one, is to get good class representatives. They have to have good facts. They have to be typical of the other class members. How many do you want to get? Do you want to get 50? In our Juul e-cigarette litigation, we have representatives from all 50 states, and we have two, one for the adults and one for the minors who started using these e-cigarette devices. They have to be smart and attentive to the litigation, and they have to be not likely to disappear on you. They have to want to be there. What's interesting and a little bit idiosyncratic is in the Juul litigation that we have a subclass of minors who started to use the Juul product and got addicted very quickly, not even knowing there was nicotine in the product. Well, as minors, the class representative is their parent or guardian. They're the ones who retain the counsel and prosecute on behalf of the minor. However, during the litigation, the minors turn 18 and they become the client. And in many instances, those teenagers said, no, I'm not doing this. I only did it because my parents made me or they were going to take away my phone. You have to make sure that the clients are willing to preserve the evidence. In the auto defect area, I can't tell you how many times we tell them, and there'll be a class representative who has great facts, we've asserted them, we're well down the pike in discovery, and they sell their car because they're sick of the vehicle, they can't drive it, and they don't tell the lawyer. That's a big problem. So you have to keep in constant contact with your class representatives, and it's not easy to do. You really need kind of a group in your firm to do that and keep them regularly updated on the litigation with emails and phone calls, and that also helps in the class certification process to show that they're adequate class representatives, which is a requirement of class certification. You have to prepare them really well for their depositions. It's not easy to do. They can't take notes because those notes are discoverable. You have to spend kind of hours re-going over the testimony, and often they will forget. It will not come out the way that you've rehearsed. Next, you have to be relentless in getting the company's documents and third-party documents. I think your whole discovery process here is very different than what we have here. Discovery is a formidable fight, and it's really important that documents tell the liability story. So before you even engage in discovery, you establish ESI, electronically stored information protocols with defense counsel. You choose the custodians to search for documents, and you choose the search terms to be applied. Those are all critically important points in the discovery process. You have to have a document review team in place. They have to be very good. And there's this whole issue now of bifurcating discovery, because in America, the class certification process occurs before the summary judgment process. And defense counsel also almost always wants to bifurcate discovery, saying we're going to only give you documents relevant to class certification, but not for the ultimate liability to be decided in the summary judgment motion. However, when it comes to class certification, they argue that you haven't shown enough. And of course, you haven't been given enough documents to show enough. So that's always a battle that goes on in the discovery process. And lastly, I would say, you have to know your inflection points. You have to know when you have the most leverage to possibly settle a case. And of course, that comes after the motion to dismiss decision, after the class cert decision, where defense counsel is more likely to sit down with you and possibly talk settlement.
Thanks, Russell. I have to say, before listening to Russell, I hadn't sort of thought about the practical reality of your class rep or disappearing on you. I think here, when we had three class actions certified in the CAT, I can see one of the class representatives sitting here. He's not disappearing, but that practical issue was a new one. I think someone at the beginning, earlier today, was mentioning that the a class action law has a lot more to do than a typical sort of individual or two-party piece of litigation. And I think that's certainly borne out in what we've seen in the Competition Appeal Tribunal here, and it's very much set out in the rules as well. And there's a lot for them to really get right. And I've heard someone refer to it almost as the lawyer being the sort of producer-type role in putting together a major film. They've got so many things to pull together, as well, of course, as the legal merits analysis and the quantum analysis. You've got to select the right class rep. You've got to have the right governance plan for the class. You've got to sort out the funding of the action and the covering of adverse costs. And of course, then do it again when I know that in the Merrick's case, after the first instance ruling where it wasn't certified, they had to find a new funder. So they had to do it all again and get new funding for the appeal process. Comms and PR, again, engaging the right people and having the right plan around that is something that needs to be worked out. And a plan also for reporting to class members and dealing with their inquiries. And also worth noting, I think, the prominence of lawyers in the court's decisions to whether to certify at all. So you have a sort of your CV, if you like, your experience is put to test in carriage disputes. There's the guidance here, and this has come up, so that one of the factors I'll consider about which horse to back, which class is certified, is the experience of the lawyers behind it. That won't be new at all to US ears, but it's a new prominence for lawyers here, I would say. And then before you get to any and all of those practical issues, you really have the creativity in coming up with the case in the first instance. And I think if you take the 3 examples that have been certified so far in the Competition Appeal Tribunal, I think it's fair to say you would never have anticipated those 3 being the first to be certified under our regime. The Merrick's case, an absolute whopper, the biggest case we've ever seen. I don't think anyone would have anticipated the creativity or to bring that on as the first case to test the system. Paterell, a standalone case based on no competition or no regulatory infringement. And Gutman, as someone was mentioning earlier, arguably in the consumer protection space rather than the competition law space, but using that competition law angle to bring it in. So obviously we'll have to see whether that creativity, whilst enough to get certification, actually goes on to run the course and succeed. But certainly those cases have been got going. So let's move on to key issues then for defendant class action lawyer. And Seth, were you going to kick off with some of the defendant class action?
Sure, thanks, thanks, Ed. So to provide the sort of U.S. defense side counterpoint, I think from a defense side, obviously not going through all the preparatory work that Russell's describing in building the case. Once the case comes in, it's a matter of building that defense, and it's very similar in many ways to the way you would approach any defense of litigation. But there are a couple, I think, particular strategy questions that you need to think about at the outset, particularly because, in the U.S., particularly the discovery costs can be monumental and can really drive how you evaluate the exposure. And so at the outset in the U.S., when you can file a motion to dismiss under 12b-6 to dismiss a meritless claim, and it's making the strongest arguments you can, because after that stage is when discovery would kick off. And so it's always been difficult, but I think increasingly difficult to dispose of claims on just a pure basis that there isn't a claim, there isn't a plausible claim, no matter, even under the standards in Iqbal and Twombly that Russell's highlighted, courts are often find there's a sufficient plausibility. So the arguments that have prevailed or do prevail are ones that are sort of almost pure questions of law about standing, whether the named plaintiff, the plaintiff representative in the class, has a sufficient injury in order to assert a claim in federal court. That's a federal issue, not a state issue. But also whether there's personal jurisdiction, whether the defendant can be hailed into court in that particular state or even in the United States anywhere, and then also the class action waiver point. Those are the 3 that have been the most successful at the outset of disposing of a claim. But if a defendant isn't able to prevail on that, then they're facing the issues of responding to discovery and certainly preservation and dealing with electronic data and the costs and analytics of conducting a review and searching for relevant documents. And Russell, I had to circle it because you anticipated my argument. As a defense, you want to bifurcate your discovery and to reduce your costs, because class action discovery on its own can be lengthy and expensive, dealing with facts on both sides, of both discovery of both the defendant and of the named plaintiff representatives, as well as bringing in the experts on both sides to talk about whether the class should be certified, whether it meets the standard under the U.S. for whether the claims are typical of the class, whether the representative is adequate, whether there are common issues, and whether those common issues predominate over any individualized issues. And so, so certainly we think that class discovery can be efficiently bifurcated to determine that issue, because whether or not that you'll be facing a single claim or a small handful of claims or an entire class of claims can really drive the economics of how a defendant might view that exposure. And one of the things we often think about is at those touch points, after a motion to dismiss has been decided, before class cert discovery or before class certification has been granted, is to think about what is the exposure here, what is the likelihood of a class being certified,
and what are the costs of achieving those results? And is there a way to achieve an economic result now that will take into account the probabilities of those events occurring and the costs of achieving that defense? And so certainly thinking about it from an economic cost point of view as well as an exposure point of view, and thinking about different ways to approach the defense in an efficient way.
And I guess just picking up from a UK perspective, and I think I can touch on these points quite lightly because I think they've been covered in different parts of the programme for this symposium. But the first point is obviously strategy and legal argument. And I would say that defendant lawyers have a really important role in designing and delivering a strategy that is appropriate for the particular client, and that might be different amongst the class members. And so, in some of the portfolios I've worked on, there may be very distinct differences between clients in terms of their appetite for litigation risk and also how the law has developed and evolved. But what's common to all defendants, in my experience, is their aim to try and close down the book as quickly and as cost effectively as possible. But an example is, and I guess there's different, we obviously have a very different approach to disclosure here in the UK, but some clients will be quite happy to make disclosure early, sometimes pre-action. Some clients will not wish to do that, and neither is wrong. It's just a question of developing the right strategy in the right occasion. One of the other major issues for the defendant lawyer is geography, and I think my partner Christian will have discussed this in his session yesterday, because obviously a lot of these issues are not restrained by borders, and you need to be very careful that the integrity of the strategy is maintained so that the issues can be litigated effectively across potentially multiple jurisdictions. And then, of course, the other example where I've got sort of quite key experiences is developing test cases, which the key thing here is if you're going to try and take one or sometimes two cases to a higher court to get a decision that is binding across the class, then you've got to be very careful that you identify the right cases which are going to provide a comprehensive decision so that claimants can't then going forward cherry pick and try to distinguish the cases as not being applicable to them because they might say, oh well, I've got different evidence that I wish to adduce in this case. And obviously proportionality is key in all of this, and I think that's something that was just similar both sides of the Atlantic. In many of the cases I work on, it would be great to run a strikeout application early doors. However, the costs just don't justify that, and we consider that the arguments can be more compelling after trial. Second point is practical arrangements. I mean, some of the legal issues are the more interesting, but I would say that the practical arrangements are absolutely essential. And I think you had a session yesterday, which unfortunately I missed, but I'll catch up in the recordings, all about data collection, analysis, storage. And I think, again, that's probably something which is true for both claimant and defendant side, where it's absolutely critical, obviously, to make sure that the evidence is amassed, you identify what's privileged, what do you actually have, how do you store it, how do you access it quickly, how do you deliver it to the court, and the defendant's lawyer is expected to have answers to all of those questions and normally a bespoke IT platform to do the goods on it. And I guess that will allow you also to spot and adapt to trends, try and be proactive. What are the bad facts cases that you want to settle early? What are the forums that you want to avoid, and anticipating lines of argument? And then very briefly, the last point I wanted to make in this is about dealing with the courts, and particularly in England, how the courts have tried to respond to some of these mass claims where there isn't one group litigation order, for example, but we are dealing with volume litigation. And this is something you've got to be wary of acting on defendant side, and actually also acting claimant side, is that some of the county courts can act as a law unto themselves, and obviously inconsistent rulings, as we've touched upon, are not anyone's friend in this. But it's also about case management, where we've seen some county courts trying to corral some of the cases, run test cases, but without having proper regard to all of the representatives of both sides of the dispute. So that's just something, I guess, that the defendant lawyer has to keep a wary eye on.
Thanks very much, Joanne. Time permitting, are there any questions?
So we have a question from Andrew Hill for the defence lawyers on the panel. He asks, would you advise a defendant to oppose a GLO application? Tesco did, a GLO was not ordered, and then it faced 4 group actions.
Well, I think it probably depends on the case. I mean, a group litigation order, and we've touched on some of this, it is administratively quite an onerous burden to run them effectively. And I think you would have to weigh up whether, for example, there were legal issues that were actually applicable across the class, which might suit a GLO, and that might be the most cost-effective way of dealing with it. But I think it just would depend on the nature of the case itself, and it's something that we would always look at very closely in terms of looking at the right procedure to use in a particular scenario.
Yeah, and I think my understanding of the procedure is it's similar to the U.S. multi-district litigation, where individual litigations from different jurisdictions in federal court are consolidated in a single proceeding for pretrial purposes. And so that's certainly, similar to what we've been talking about, has some of the advantages of efficiency and consolidation and avoiding inconsistency in a non-class action or non-single class action context. And so I think that, again, in the right circumstances, can be appropriate.
Okay. We've got time for one question, or we need to wrap up? Yeah, there's a question here.
Thank you. My name is Isabella Wijnberg. I'm a Dutch defense lawyer. And I was wondering if you see a role for mediation, and if so, what are the advantages and disadvantages, and at what stage?
Anyone have experience from the US?
Certainly, yeah. We often use mediation to help resolve disputes. Again, at the appropriate stage where it makes sense to enter into those discussions with plaintiffs, and can find that having a neutral observer to help in those negotiations and help break through some of those barriers certainly is very often has resulted in settlements that both sides have agreed to and that has been approved by courts. And so yes, it's definitely part of the class action experience in the U.S. and on my side as well.
Yeah, we go to mediation whenever possible. It's extremely helpful to have a neutral third party, and often that third party is very well respected by the court. So when you submit an application for approval of the settlement, the court will look at who the mediator was, what their track record of success was. Especially a lot of mediators are former federal court judges in the U.S., so that carries a lot of weight with a judge deciding whether or not to approve a settlement.
And I think in this jurisdiction, very effective as well, however long it takes. In one well-known major group litigation action, the mediation lasted 14 months. But it did get a result, so it can be effective. All right, well, thank you very much, everyone, and thank you to the panel.
Thank you.